Hello and welcome back, Realty Pros, to another Realty Talk. We are so excited today because we are in our Upper Marlboro office and we have the pleasure of having Cheryl of Velocity with us, Velocity Title. She is a representative from one of the, if not the best title companies in the world. And she has agreed to come and join us and to share with us in regards to some of the different transaction types and what we can expect, maybe what some things are that we need to look for when we are dealing with different type of transactions. So again, thank you, Cheryl, for joining us. And I'm going to go ahead. I'm going to turn it over to you. I appreciate so much everyone for their participation as well. So thank you very much.
Hello, everyone, and thank you so much for joining us today. I was asked to come and go over some of the different types of transactions that you will encounter. The seller specifically, like when you're taking your listing and the types of sellers that you're going to be dealing with and the things you need to be asking for from your clients to be ready to take your listing. So to start off with, obviously the easiest one and that everyone's the most familiar with is going to be a sale that involves individual people. That's going to be your standard sale. You've got John and Mary Smith as your owners, cut and dry. That's very simple. If you have a seller that is deceased, that's where you start getting into something else. Now, if you have two people in title and one is deceased, it could be different. So it depends on how they, if they're a married couple, more than likely the surviving spouse is the one who has authority to sign and sell the home. It depends on how they took title. So there will always be some, circumstances that might vary from what I'm saying here. It's very, our industry is very specific, but if you have one owner and that owner is deceased, the property in Maryland automatically vests in the personal representative of the estate. Now, the estate isn't opened immediately upon someone's death. So there's a period of time between the passing of the owner and the issuance of letters of administration by the Register of Wills office. So you can deal with the person who says they are the personal rep or the executor. By the time they're selling the house, putting it on the market, they may already have their letters of administration in hand. So you want to ask for those and the death certificate. You want to get a death certificate for the owner and then letters of administration. The letters of administration appoint a person as the personal representative, and that PR is the one authorized to sell the home. That's the only person that can sell the home. That personal representative is not acting in an individual capacity. So you need no personal information from them, nor do we as a title company. It's not their property. It's not their loan if there's a loan on the property. So in other words, we won't be asking for their social security numbers. We won't be asking for, things like that. The estate will have an EIN number appointed. Like, I'm getting into a little stuff that you all don't necessarily need to know, but you want to make sure you've got a death certificate and letters of administration if the owner is deceased. If your owner is a trust, you need to be dealing with the trustee of the trust, okay, whoever's appointed to act on behalf of the trust. A lot of people nowadays have created revocable living trusts and they've transferred their properties into these trusts. You need to make sure you are dealing with the trustees named in the trust. You could ask them for a copy of the trust agreement. They might or might not. Some people don't really want to share those documents with everybody, but they usually have a shortened version of their trust agreement, and it gives you the details that you would need. Who is the person authorized to sign on behalf of the trust? So it's important that you're dealing with the person authorized to sign the listing. If you have, let's see, a company, an LLC, a corporation, any entity type, you need to deal with the person authorized to sign on behalf of that entity. A lot of times you're going to be dealing with a person who's a representative. Usually when you get to the title company, we address getting their corporate documents and all this stuff, but you want to be dealing with, if it's an LLC, the main member of that LLC. The member or the manager of an LLC is the one authorized to sign on behalf of a limited liability company. Corporations, you don't see too many of those these days, but if you do, typically it's a president or a vice president you're going to deal with to sign your listing and the closing documents. We'll obtain copies of all the corporate paperwork. You could ask for this too. It's helpful if you as the listing agent have already asked for that and can provide that to us. It speeds everything up. If you just ask them for their corporate paperwork, they'll give you whatever they have. And you can usually determine from that paperwork who is authorized to sign on behalf of that organization. Okay. Is there specific any other types of sellers that you can think of that you have questions about? Companies, estates. Okay, so they don't own title. They don't have you. You want to ask them for a copy of the deed that was issued to them, or that from when they bought the property, so that we can figure out why it's not of record yet. Sometimes hasn't been recorded yet. Okay, so really you can't proceed until the deed is of record. They have no authority to move forward until the deed is actually of record into their name. So that does have to take place before this. I mean, you could possibly take the listing, but this is going to be an issue moving forward. We have to make sure that deed is being presented for recording, hasn't been lost, otherwise you're going to delay the whole process would be delayed. But the other thing with an investor, you got to be careful on the buyer side. So I think it's something that you would want to put in your listing. This an investor they have to have owned the title. They had to have been entitled for. Gosh, I want to say I'm sorry, I didn't have this written down, but they have to be entitled for. I literally am drawing a blank right now. A certain period of time before an FHA buyer can buy that property. Thinking 60 days, but that seems too short. I'll get back to everybody and tell you that time frame. I'm just not thinking of it right now. I haven't encountered that scenario recently, so I kind of forgot that time period. But the owner has to have had title for a certain period of time before they are allowed to sell it to an FHA buyer. You'll have to wait if you get an FHA buyer on one of those transactions, you're going to have to wait until that time period is lapsed before you can go to closing. So that there could be a delay if they've only owned it for a short period of time. Let's see. So right, right. You got to wait that. Exactly. When we do the title work, there's an exception in our commitment to that effect, and it says how much time they had to have been entitled. But again, I just can't remember what they thought. If you're dealing with a seller who is upside down on their mortgage, short sales, your seller still holds title to the property, and they are the person who can sign your listing agreement. Okay. Your contract will be subject to final approval by the seller's bank. A lot of people think the seller's bank is the seller and they're the ones that sign. They sign nothing except the approval letter for the short sale, approving the details or the terms. But your fee simple owner and title, the seller still holds title to the property. They are the ones that signed your listing. They'll sign all the closing documents. They still hold title. We're just asking the bank to accept less on their payoff. The bank does get to review all of the details of that contract, and they can counter the terms just like the seller can. And they will if they see excessive closing help or warranties provided by the seller. Depending on how much we're asking them to take a hit on, they might say, no, we're not going to pay for a warranty, and we're not going to offer that 6% closing help, but we might give 3%, or, so they may counter the details in their final review process, looking at the numbers to make sure that their net is where they want it to be. But for purposes of you listing and your contract, your sellers, your people in title are the people that can sign. Mhm, mhm. Right. The seller is the name of the company. Right. The company name is what you would list in your contract as the seller or your listing agreement. The owner is the company name. It's when you get to the signature line that the representative will sign and they should put their title behind their name. Yeah. Whatever their title is. They don't sign like ABC Company LLC. They don't sign that. They sign John Smith, president or member or whatever on the signature line. Same with the personal representative. When you have them sign, they're going to sign their own name with the designation personal representative behind it. They still sign their own name. Okay. If you have a power of attorney, you've got a question? Mhm, mhm. It should already be in the listing. So when you're putting a property on the market that you know is a short sale, you're going to put language in your listing about it being a short sale transaction. Yes. And that it will be subject to third party approval. You really need to make sure that's in there. That way that purchaser understands this isn't going to be a quick transaction. It could take a while. Um, you also want to try to make sure you get as much time as possible for closing. Don't put 30 days because that's not reasonable. And you really want to prepare the buyer and the seller for that matter, that this could be a long transaction. I recommend 90 days from the date of execution of the contract. We sometimes don't hit that mark. But if you put 90 days, your clients are all on board for that. They're going to hang around for a while. You want to know they're in for the long haul on a short sale. Yeah. Get as much time as you can. I was going to say something else, but now I forgot. Okay, so on some of these, but would you like that? Want some more information? Okay. So we said estates, in an estate, we have to pull all of the estate documents before closing, and we're going to be looking at the will. You may want to ask for a copy of the will. That's a good thing to have in hand. Okay. The will tell you if they have devised the property to someone specific. If I pass, I leave the property to my daughter, Nicole. Property has to go to my daughter, Nicole. If the will says it goes to someone specific, that's who it has to go to. Now, if that person has said, you know what, I don't want it, it's okay, I'm consenting to it, that's good, but that's something you need to know. You need to make sure the person that was named in the will that the property is supposed to go to is agreeable for it to be sold to a third party. That person that was named in the will have to join in the execution of the deed to confirm their agreement that they're not getting the property and they consent to it being conveyed to someone else. Okay. Right. Correct. Well, right. And now sometimes they can be the personal representative. So they could be one and the same, but they don't have to be. Right. Right. But you do want to make sure, and if there's no will, that's okay too. Then you've got your PR, your personal representative can sell the house. That means the person did not leave that home to someone else. Okay. If there's no will, that's fine. Um, Another thing we have to look at is in the estate filing, they file a petition for this probate, and they list an inventory of all of the assets of the decedent. And the property you're listing needs to be listed in the inventory. It has to be in there. You also, if they provide you a copy of that, we double check this at settlement, but if you get copies of their estate documents and you look at that inventory and you see it on there, they will have a value. And so you need to make sure you're not listing it, it needs to be close to that number. Otherwise, the courts will have to approve the sale. Okay, so they've established a value in the estate petition, and that sale price needs to be close to that or above. And if not, we would have to get approval of the courts to sell it for less than what the inventory said the value was.
Hey, Cheryl.
It depends on what the seller has done. If they haven't, I suppose some people jump straight to, oh, got to sell the house, right? As soon as the owner passes. But and they can go ahead and start, but you really don't have a PR. You don't have an authorized party to sign the listing. Okay, you've got to have a personal representative. That's the person that needs to sign your listing agreement. So really they have to have, and if the letters of administration have been issued, then there's already a petition filed, and the inventory should be in the estate documents. Mhm. Well, I believe that the court may approve a lower price. They might have to, I don't really know what higher is fine. There's no problem with higher. It's only if you're trying to sell it for less than what was reported in the inventory that its value was. If it's valued at $200,000 and you're trying to sell it for 150, the estate will want to, the Register of Wills office is like, hey, you're taking $50,000 away from the estate that they should have been given in proceeds. So you can go to 300,000 on your sales price, but we don't need approval of the court for a higher price, because all the proceeds go to the estate anyway in the end. Okay, and then they distribute to whoever the heirs are. Mhm.
Hey, Cheryl, can you hear me?
I
Can
need
you hear
mute.
me? It's Kermon. Can anyone hear me?
I can hear you, Kerma.
Yeah, my question for Cheryl was if someone passes away and the house is still has a mortgage, can the people who were living in the house, let's say her children, just continue to pay the mortgage? Do they have to let the bank know that they passed? And what happens in that situation?
Just 1 second, come on, can you repeat that question?
Okay, so my question was, if a person has a home and they have a mortgage, they're still paying a mortgage, and the person on the mortgage passes away, and there's no one else on the mortgage, but let's say the kids or someone else is living in the house, can they simply continue to pay the mortgage, or do they have to let the bank know that they passed, and do they have to sell the property?
Okay, so if I understand the question,
Sorry about that. Go ahead, Cheryl.
So the owner passes, and you're just asking if the heirs or people living in the house and they continue to make the mortgage, can they do that? Is that the
Yes,
question?
yes,
Okay, so you probably aren't going to be involved with them if they do that, right? I'm guessing they're not trying to list the property for sale.
right.
But yet technically, yes, they can, because the banks don't really care. As long as they're getting their mortgage payments, they're not going to They're not going to come after the people and say, hey, the owner passed, we're going to foreclose, because they really don't want the house. They want the money back. They want the payments. So as long as the payments are being made, and a lot of times when an owner does pass, the heirs are still keeping the mortgage current, and they do that to protect their interest in the estate, because the estate proceeds in the end will go to them. So it's to their benefit to keep the mortgage payments current. So yes, they can technically do that, because the banks probably would not flag the file for foreclosure just because the owner passed, as long as the payments are still being made.
So what happens if they want to either sell the house or refinance or whatever, and then the bank finds out that the person's been deceased for years?
Okay. They can't refinance because they don't own it.
Right.
They can't sell it because property is vested in the personal representative. So they have to open the estate and have letters of administration, have a personal representative appointed to sell the property. They can't refinance in the estate name. They would have to, the personal representative would have to deed it over to someone. There would have to be a transfer, and then that owner could do some financing possibly at that point.
Okay. Thank you. Perfect. Got
That
it.
answer the question?
Yes, it did. Thank you.
Did you have a question? Well, when the petition is done, the owner or the petitioner, typically the person who was named in the will to be the personal rep or the executor of the estate, the one that's filing the paperwork with the Register of Wills office, they're the ones that would what was your question? Who establishes the value? I know I was getting away from those, talking about owners, and your question was value. They fill out the value on the inventory form. Now, I'm not sure if they do an appraisal in the estates. Now, I know I have seen appraisals done in estates. I don't know if that's when they are, values are objected and that kind of thing. I think the owner sets the value. They put it in there, yeah. No, the person that's right.
And they establish the value. They fill out what's that form you said they.
It's the petition for probate. Now they will also as a part of the petition, they're going to put a copy of the assessment record in there that shows a value, so they're going to be in the ballpark, with the assessed value anyway, using, because that's filed in the estate as well, the assessment records. Right. We've been all over the place. Do we have any other estate questions? Maybe we should do that first and finish up. I don't have any other notes on estates, but
Yeah. Not established, and that's doing it.
okay, so let's say, right, let's say I own a house and I passed away. I did not have a will. I didn't name anybody. I didn't appoint anybody, but I have family that somebody's going to step up and say, hey, I'm going to go apply for, that's what happens. Somebody, a relative will go. And let's say I have two children. One of them petitions the court to be the personal representative. They will have to name any interested parties on that petition. How many, any heirs, any siblings, any spouses, any grandchildren, any, what they list the heirs of the decedent on that petition. And if they're, and they will have to consent to some of the things. It depends on what it is, but so if anybody wants to contest any of the information, they can do that. It's all done through the courts. The Register of Wills will put an ad in the paper once that petition is filed saying, so-and-so has applied for letters of administration for this estate. If anyone objects, you've got, 2 weeks time, or whatever the time limit is, to 3 weeks, I think, to object. If no objections come in, the courts appoint that person as the personal representative. And then that person can move forward, to list the property and sell it. Yes, that's the key to all of this, is that if it's not an individual person that you're dealing with, you want to get paperwork for whatever, however, what kind of an owner it is, whether it's an estate, it's a trust, it's a corporation, it's a limited liability company. If it's anything other than an individual, you're going to have paperwork, and that paperwork should identify who is actually authorized to sign on behalf of that company or state or whatever. There should always be paperwork. You want to ask for it. Right. And you might not get all of the documents that are required for settlement. And that's okay too, because once you get your under contract and you've sent it to us, we're going to ask for that same paperwork. And so you, as the listing agent, if you've got some of the paperwork, you're going to give that to us right from the beginning. Then we know, okay, well, we're missing a death certificate, or we're missing the letters of administration, but we have a death certificate. We'll start inquiring and ask for these things. We'll check the estate records and we'll pull things from there and get what we can. But sometimes we'll have to go back to the seller and ask for additional paperwork. But some of the stuff is available in public records, and some of the most important things on a limited liability company is the operating agreement. Okay. The operating agreement is not recorded anywhere. It's not in the business record where they file their articles of of organization. I was thinking articles of incorporation, but where they file that paperwork, the operating agreement is not recorded. And the operating agreement lists specifically who the members are, if there is a manager, and who is authorized to manage the LLC. One of the biggest concerns on a limited liability company is if there are multiple members and the operating agreement says they all must sign, and you're dealing with one member or 2 out of 3. All members, if that operating agreement says they all have to sign, they all have to sign. You can't move forward unless you have them all. Some LLCs do not have operating agreements, and that's okay too. Most of the time, single member LLCs, they are the ones that typically don't have an operating agreement. It's one person, and that's fine too. So when you have a single member LLC, that person, we need more personal information from them. You all don't need to get it from them at the listing time, but it's a little different when it's one member with an LLC. We do need their personal social security number. We have to run them in bankruptcy courts, things that we do on individual people. But that's the only entity where we do require personal information from the representative of the limited liability company. It's when it's a single member, when there's only one, because they're really acting more on their own behalf, so. No, you wouldn't need to worry about that. Right. You want to make sure you can ask them for their organizational documents. Again, like I said, you're going to ask if it's any type of entity. Can you give me your paperwork for ABC LLC or ABC Corporation or, Cheryl Latham Trust? You need the paperwork because that's not a person. You want paperwork that shows that. Then when you read through this paperwork, you're going to see it names somebody. It names somebody to act on behalf of that entity or that estate or trust. And you want to make sure you're dealing with that person, that individual person that represents that company. One thing I did also wanted to say, because we've seen so much of this in our industry, and we were involved in a case that this happened on recently. Vacant land is a target for fraudsters right now. People are identifying pieces of vacant land, and they're contacting realtors and saying, I'm the owner and I want to list this property for sale. So these properties are getting listed, and you really need to meet your client face to face. That's really important that you meet them face to face. At some point, at some time, it's even if it's a Zoom call sometimes, that at least you're at least seeing them. If they contact you by email and only talk to you over the phone and can't meet you, these are red flags that something might be going on that's not legit. We had this transaction recently, and this person provided a fantastic Maryland driver's license as his ID. You couldn't even tell that it was not a legitimate identification. And we got all the way to the settlement table. The buyer paid all their money, went to closing. The seller was supposed to do a remote online notary appointment with me, and he kept making excuses about how he couldn't get connected and he couldn't get in the portal and it wasn't working. And couldn't I just email him the documents and he would go get his own notary? Well, we don't allow that anymore. We used to do that in the old days. You just email documents to a person and we'd let them go get a notary. Well, not anymore. You can't do that. So I stood my ground with this guy and said, no, we can't, I can't send you the documents. Well, he dropped off the face of the earth and we never heard from him again. So we did find out it was a fraudulent seller. He was not the right person. So you may want to check IDs. You may want to come up with like when you go on your listing appointments, say, it's one of the things we're required to do. It's easier to say somebody else makes me do it, but I need to see your ID and take a picture of it. Put it in your file. You've got an ID of that person. You're dealing with the right party. You don't always have to do that. We're going to get IDs at settlement as well, but it's just another thing you can do to make sure you're not wasting your time. Because I know the agent on this transaction that we worked on, both of them were very upset at the end of the transaction that it just fell apart. So right from that beginning, that listing, you're there, you're meeting the seller, you're asking for all of their paperwork that shows the ownership of the property, and getting ID and making sure that you're dealing with the right person that it has the authority to put that property on the market. A lot. Mm-hmm. Yes. Yes, there is. There's a lot of wire fraud as well. Yes. So one of the things we use is Qualia, and those of you that have used us know that. and that portal is very robust. And when I say that, I mean it. It is super secure and safe. So we really try hard to communicate with clients through the portal. Some people don't really like doing that, and we can work around and navigate it without it. But that portal is where we send them our wiring instructions, or they're safe. I had a transaction also where I emailed a client wire instructions. This was not when I was with Velocity, but I emailed my client our wiring instructions. And a little while later, I get a phone call from the client. He said, okay, I've wired the money. And I'm like, I don't see the money. I haven't seen it. He said, oh, I got your email that said your wiring instructions changed. I was like, oh my gosh. I said, look, our wiring instructions did not change. Forward me that email. You call your bank now and try and stop that wire immediately. But luckily, he called me soon enough that he was able to stop the wire. But these fraudsters are so smart, and they're targeting real estate agents. And I've heard they target Gmail. I don't know why. I don't know what makes Gmail anymore. I know, I'm not a techie person that way. I don't know why Gmail is a target, but they know real estate agents are doing these transactions and going to be talking about escrow money left and right. So they're watching for these emails, and somehow they are blocking them and sending out another one. They used my signature block in my email to this client. It looked like it came from me. So we to encourage them to use it. Yes. That's great advice, to always verbally approve those wiring instructions with somebody over the phone. Yeah. Yes. Yes.
Okay.
Mm. So I haven't heard of any specific cases myself. I've of course seen the same commercials you have, and that is very scary to be honest. I believe that the people that are targeted are the homes that are paid off. If there's a mortgage, they're not gonna, they really can't do it. But if it's free and clear, yeah. Now, one thing that is important is if our purchasers, we encourage them to buy the enhanced Eagle policy, the owner's policy. They can get a basic owner's policy that guarantees that no one, that they own their house, but they can also get the enhanced Eagle policy, which gives them added protections. And one of the added protections is that service specifically. They're automatically covered under their policy. So if you have a prior client that we closed and they ask you that question, their title policy insures them for that. So for any forgeries after their deed is of record. And that's just one of the added benefits of that Eagle policy. Hmm. Right. Hmm. Right. Hmm. Hmm. Yeah. That is a great question, Kerman. I am not 100% sure. I believe the answer is yes, because I know a title insurance company would love to issue another policy to somebody because obviously there would be a premium involved with it. But that's a great question. I'm gonna get back to you on that with more details because that is a really good question. Yeah.
Hey, by the way, we can't actually hear through the web video the questions being asked. So if you could do us a favor and just repeat what the people that are asking questions are asking before we answer, that would be helpful. Thank you.
It's a good thing to ask. I'm sure you ask, what mortgages are on the property, how much do you owe, and that kind of thing. Good to ask those questions too. Do you have any judgments or liens against you? They're going to show up when they do the title search. It's great to get ahead of it. Let me know how much that might be. It'd be good to figure that out. It also lets you know if there's enough in your net, you do your seller net to make sure they have enough to pay everything off. But that's. No, I don't think you should have to, but I mean, yeah, I mean, the Maryland judiciary court records are public and you could jump in and run your owner's name if you have. Mhm. Okay, so creditors have to look to the estate for payment unless a lien has been established of some sort that's recorded in land records, and it had to have been recorded prior to the passing of the owner. Otherwise, it doesn't attach to the property. So if there's liens of record before the owner passed, those would have to be satisfied as a part of closing. If they are just creditors, they're like, oh, this person owed, Citibank $3,000 and, whatever, a whole bunch of debts. Those creditors, what they do is they file a claim against the estate, and that's filed in the estate. And the personal representative has to deal with the creditors once they get the proceeds from the sale. So it's not addressed as a part of our closing unless it's a lien on the property. Any kind of lien or judgment that's recorded. So if the owner had a credit card and they didn't make their payments, that creditor might sue them, take them to court, and get a judgment. And if that judgment is entered before the person dies, it automatically attaches to any real estate that they own in that jurisdiction where that judgment's entered. And that's a part of the abstract that we do. We double check the courts and judgments and all of that. And if there are any that are against the decedent prior to the date of death, then we have to satisfy them. Anything that shows up after the date of death, it's too late. It doesn't attach to the real estate. They can file a claim against the estate, and their claim is addressed through the estate money, the proceeds that come out after settlement. Correct. Well, they file it. They don't send it directly to the executor if talking about the claim. They file that with the court. The courts, once they get a claim, they mail a copy to the PR, to let them know. What? So, do you know? I mean, I guess it depends on what still needs to be done. Mhm. Okay. An attorney to handle the estate for her. Mhm. And the attorney's not getting back to her. That's very strange now. So I think the first thing I would do, I would probably call the Register of Wills directly and ask them, is there something else that I can do to get this closed out? I can't get a hold of my attorney. I would try that. The reason I say that is the Register of Wills office, they're usually very, very helpful. Those people are so nice. I think they understand what people are going through in that department, so they've lost somebody, and it's a sensitive situation. So they're usually very helpful. So that would be my first suggestion. I mean, then beyond that, I file a complaint with the bar because the attorney's not getting back with them. I don't know what you do about the attorney. Oh, gotcha. Okay. What's going on? Right. And he has nobody else, no paralegal, nobody else. He's probably a one-man show, probably. Right? Okay. Sure. Okay. Yes. Mhm. So if it would probably be a short sale if those liens are, yes, you would then be dealing with a short sale situation. Now, a lot of times when you're dealing with like if there's enough money in the proceeds of the property to pay off the mortgage will be paid in full. It's the judgments then that you start negotiating with. And depending on the timing of, how long they've been there and that kind of thing, a lot of times you can negotiate those down, Yeah. So just it's similar to a short sale, but it's really just negotiating the judgments in that scenario, though. Okay. Anybody else? Thought of something a minute ago, but we've gotten off onto something else, and now I don't remember. I thought of something else that I thought would be good to mention to you guys, but
I have a quick question, if I
here's
could.
Curtis.
Yeah. So quick question. I'm working, actually, I submitted an offer on a property that looks like it's an estate sale. The interesting thing is that there seems to be a HVAC system that was leased from the prior owner. And I want to make sure that, because it looks really weird. Like typically you don't lease your air conditioning or, your HVAC. You got a loan out or you bought it and now you own, the HVAC. But for some reason, there's a lease attached to the property, and I want to make sure that it doesn't convey with my buyer if our offer is accepted. But I just wanted to ask, how would you get out of that, like, or not have my client be, you know, I know they don't want to have a lease HVAC system. They would rather have a system that they would own.
Right. I have never heard of this before, ever.
Right. Okay. Yeah.
I would
It's
love to
really
see a
weird.
copy of that lease agreement, to review if you have it and can forward
I
me a
have it.
copy. I would love to look at it.
Yeah.
I believe this would be something that the seller would be responsible to resolve. They would be responsible to get a hold of the person they're leasing it from and pay it off. It's
Right.
being leased, but it's got to be paid off. That's just very strange. I've never heard of that.
Yeah. Even the listing agent was kind of was like, she doesn't know if, I'm assuming it was an older owner, if they got somewhat scammed or got pulled into some weird, because it's even the lease document, it's like $36,000 essentially for an HVAC system over the course of the term of the lease. They're
Oh
paying
my
like three,
gosh.
yeah, like 300, about 250 to $300 a month for the lease. And I'm like, yeah, just so I'm glad you never heard of anything like that, because I was like, I've never heard of anything like that either. It just seems really fraudulent on, you know. But I'll
Right.
definitely send you a copy. I have it.
I would love to see a copy of that.
Sure. Yeah, we'll do. Thank you.
Yeah, because that's very strange. I have never heard of that happening. I mean, obviously, learn something new every day in this business. So, yeah, so when you
Sure.
when you pick up on something that's a little outside the box, certainly have a conversation with somebody and try and figure it out, because everything's not, black and white. It never is in our business. There's just so many gray areas in what we do. Reading details is really important. That's why I say, ask for this paperwork up front, look at it, make sure the person you're dealing with is the person named in the documents. That way, you've got a legitimate, listing, and important to know you're working with the right people, you know? Okay. Okay. Mhm.
I know whether or not
Right.
buyers.
Hmm. So I don't think you need to worry about the buyer, because the buyer is going to go to the lender, right? And the lender's going to pull their credit. And if they have a judgment against them,
Seller. Find that information.
okay, well, you would find out before the day before settlement, because we would have the title search long before, and the title search is going to show. Right. That's true. That's true. Um, yeah, that's true. But I mean, hopefully these other title companies are communicating with you. Yeah, we're gonna let you know. Right, we're gonna let you know. Yes, yes. I'm like, so you're dealing with a title company that's holding the information back. I got it. All right. Right. Oh my gosh. Okay. Okay. Yeah. I mean, you've got the contract, you've got the seller's name. I mean, you could run their name in Maryland Judiciary. Like I said, do the Maryland Judiciary case search, and that's free, and you can plug their name in. The only problem is, if his name is Paul Jones, you're really going to have a hard time narrowing it down. But now you can narrow down your search by, if you get too many results, to a specific county where the property is located, because it has to be recorded in the county where the property is located to be a lien on the property. So limit your search that way. That'll help. But but by the time you got an inkling that something's wrong, it's probably last minute, right?
Yeah.
Oh my gosh. Mhm.
So
Yeah, it gives you, so if you click on the case, once you get your results up, you click on the case number, it shows you the docket entries. And it shows you the plaintiff and the plaintiff's attorney and the defendant, and if there are attorneys, their information will be listed on there. And then it has like clerk's little notes about the different events that have taken place since the action was taken. Sometimes you can't really tell what these things say. The word order is something we tend to look for in all the little notes. If there is an order, that means a judge has signed something. So those are the orders, are the things you want that will jump out at you on these case searches. But yeah. Mhm. Mhm. Now, some listing agents will email me and ask me, if, how's the title look? Is everything okay? I mean, I think that you're fine to ask. Now, whether they give you a good answer or not, I mean, I think, you're free to ask the title company or attorney, want to make sure the title looks good and there's no liens, judgments, nothing's going to hold up settlement. I would reach out to them and ask that question, a week or two before settlement, make sure you're still on target, because those are things that, yeah, pop up at the last minute. Change your plans. Right. Yes, that's fine. I love it. Okay, so we should be sending you the final ALTA for review, usually 2 to 3 days prior to closing. Now that's assuming the lender has balanced the CD with us, because we typically aren't sending out an ALTA for review until we balanced with the lender. Okay. Now, if you're on the listing side, you don't care about the buyer side, and we could send you a seller ALTA ahead of schedule. A lot of times we send those if we're doing a seller pre-signing. Lots of sellers are doing these remote online notary appointments, so they don't have to come closing. And they usually sign 2 or 3 days prior to the buyer. So we're going to send you the ALTA before your seller signs, because we want you to look at it, make sure their numbers look good before we have them sign. And it's not always a certain time period, because again, every transaction is so unique in the details. Sometimes you're still waiting for something. We've got a case of settling on Monday, and I've been emailed by the listing side so many times asking me for the ALTA, and I can't send them an ALTA yet for the seller because I have an unreleased deed of trust, 4 possible prior owner liens, and we have been asking the seller repeatedly for his owner's title policy to clear these issues. And we just got this policy last night. So here it is, Thursday, and we haven't sent out the prelim out, because I mean the numbers could change. We don't know if these things are all cleared, or if we're going to have to collect money to satisfy them. We didn't know, so. Okay. You right. Mhm. Right. Okay, so in Maryland specifically, because that's really where we see it, and like I say, mostly in Baltimore, we go to the SDAT assessment record. And if you're familiar with that, do you all use SDAT? I think MRIS is comparable, and you all use that all the time. But do you go to the SDAT records too? Okay, so that's where we go for the ground rent. So as soon as we see that a property is leasehold, subject to a lease, and it's ground rent, we go to the SDAT record, and it will say at the top left-hand corner, it says it's ground rent. I forget what the words are up there, but you click on that and it takes you to the ground rent registration page. Okay. The owners of ground, and this just recently changed. So the owner of the ground rent, the holder of the ground rent, they have to register their information on SDAT. So if it's registered, you know who the ground rent holder is. You've got their information, it's right there. If it's registered, your seller knows who they're paying the ground rent to. So you want to ask them who that is. It's just like taxes, or, you know, it's stuff that gets prorated at settlement. We have to make sure it's current at closing and all of that. We'll need that contact information of who they pay the ground rent to. Copy of their invoice. They get an invoice every 6 months. It's payable biannually. Ground rent is. If it's not paid, yes. If they don't pay the ground rent, yes, they can foreclose. Yeah, they can. Mhm. Yeah. Now, they have to be registered. So here's the cool thing for us anyway, from the title perspective. If they weren't registered and the owner hasn't, and this happens a lot, people don't know who the ground rent is paid to. We used to have to escrow 3 years worth of ground rent, still prorate it and do all this on the settlement sheet and hold this money in escrow for 3 years, because that was the statute. A ground lease holder could come back anytime within 3 years and say, hey, you owe me $6,000. So the laws have changed. They have to be registered. If they're not registered, we don't have to escrow, we don't have to collect, and that ground rent holder is barred from being able to collect anything prior to the date of our deed. Now, if you have a purchaser, though, we advise them your property is still leasehold property. It is still subject to this lease. And the ground rent holder, the leaseholder, could come forward and start collecting the ground rent from you. And they could, but they can't go back in time. Right. They can't charge them prior to their ownership. No, not usually. It's paid separately. Depends on the lender, I will say that, but most lenders don't escrow for ground rent. It's biannually, and it's never a lot of money. It's never a lot. It's $120 a year. Okay. And it's $60 twice a year. So it's paid usually January and July or something like that, December and July. Yeah. Usually the ground rent holders send out an invoice every 6 months and tell them, you know, here's your bill. Send me your $60. Right. Hmm. And then there is a process for the owner to pay off the ground rent and merge it so it can become fee. They don't have to stay ground rent if they don't want to. Ground rent holder you just ask for a payoff and they provide a payoff. If you don't know who they are, there is still a court action that they can file to dispose of the leasehold. But you've got to go through an attorney and file an action if you don't know who the ground rent holder is. If it's ground rent, yeah, they should be disclosing if it's leasehold. Mm-hmm.
Fine. Right? And there's no front.
Right.
And all of a sudden, you're going to notice. How does that work?
Okay, so front foot benefit charges take priority over a deed of trust. So so in other words, if a ground rent holder comes forward and it wasn't paid at settlement, FFBC comes forward, they can collect all of what's due. It's a lien already on the property. It's not like a judgment, but it's like a deed of trust that's already of record. If that front foot benefit agreement is of record, which it has to be, it's a lien on the property. So if it's not paid at the settlement, hopefully they bought title insurance because they'll file a claim under their policy, and the title insurance company will pay the back fees. Buyer's still responsible from settlement forward, from the date of their purchase forward. Yes. Yeah, when we do the title search, the front foot benefit charge agreement is recorded and it's given to us as part of our abstract. And that's how we know there's front foot. Okay. Anybody else? Sure.
Yeah, what's needed? Like dealing with, I mean, if someone passed away, now dealing with.
Okay, so on a reverse mortgage, if the owner passes away, they will call that loan due. That's the one scenario
Yes.
where the heirs can't keep making the payment because the reverse mortgage company wants that money. And as soon as they find out the person has passed, they're gonna start collection or, say it's due. But so what specifically was your question? How do you,
Yeah, I just wanted to know how would that handle?
that is,
Really
okay,
what happened
okay,
that Some do it a certain time.
right.
Come up with, but you have the option to sell it.
Yes.
So you do
Well,
have
you'd
an
have your
option to
PR in place, right? The personal representative or whoever would, yes,
sell that property.
and pay off that
And-
reverse
but do
mortgage.
they have to sell it within that period of time? Yes.
I believe so. I'm not 100% sure on that. Maybe, I mean, I believe if they work with the lender, do you know something about that? Okay, they'll probably give it. That's what I was gonna say. My guess is the lender, as long as you're communicating with the lender and telling them what you're doing. Like, let's say they put the property on the market right away and they're doing everything right. For whatever reason, it's not getting sold in that 6-month time period. They can show the lender, hey, look, we put it on the market and we're working on it. We've lowered the price, we're whatever. I believe they would work with you. Oh. Mhm. I'm sure there's something in the details there that they have to sell it for full value and that kind of thing. Yeah, they can't sell it to the granddaughter for 30,000 less than the actual value, that kind of thing. Exactly, right. It's kind of a pre-approved short sale. Right, they'll take it. Right. Well, that's interesting. I like that. Right. Mhm.
So, I guess for this order was more. I was asking, you know. Oh, well, like. I think that it depends on. that- I'm just hearing all these different scenarios about. Daughters that I have. So her situation might be she can take it. She said, Valley. So. That is, I have 1 year. Because she's the daughter of mom.
Now, your scenario was the owner is still alive. The borrower is still alive in your scenario. Yeah, I think I was gonna say that too. I believe that's part of, yeah, once it, well, they could just leave it and let the bank foreclose if they wanted to, but but you want to convince them to get the listing and get it sold because they might, I mean, are they trying to walk away because they think they're upside down, or are they just? Mhm, okay, going for less. Take a look at it. Mhm.
So it's not bad.
So maybe ask them to request a payoff statement for you. And that way you have the actual figure that would be due to work with, and then you could run your numbers and see if it's
I
doable.
feel like those rules have to be released. Because some people have a reverse mortgage, and if they end up in a. So your house just can't.
Right,
Gotta be some. You have to reside in the home.
right, right. Right, they have different programs, yeah. Right. Right, right. Yeah. Hmm. Okay. I don't think so. Thank you, thank you. Thank you, everyone. Well, you can call me anytime, Vermont. I love hearing from you. Here it is.
All right. Thank you so much, Cheryl. We appreciate you being willing. We covered a lot of different topics. So that was really great. And so we appreciate you taking your time out and being with us, sharing with us. I think that everyone got a lot out of the information that you had to share. It also brought up a lot of questions, which was really great. So we appreciate you. We appreciate all of you who were able to join us online as well as obviously in the office. We're going to go ahead and we are going to stop our recording and then we will